Today, I will tell you how to move your corporation from New York to Florida. First, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at the university level and hold 4 degrees, including 2 law degrees, as well as a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law, not .com, but .law. Redomestication is the legal process of transferring an existing entity from its current state to a new state without forming a new business entity or merging with another entity. Unlike foreign registration, which requires maintaining compliance in 2 or more states simultaneously, this redomestication process terminates the legal nexus in the original state when performed correctly. This avoids duplicate annual reports, franchise taxes, and registered agent fees. Unlike a statutory merger, redomestication does not involve transferring assets, liabilities, or contracts between 2 entities. Rather, it simply changes the jurisdictional origin of the existing entity while preserving its continuity, federal employer identification number, contracts, and in most cases, the name of the business. The redomestication process requires drafting and adopting a formal plan of conversion, which is a bespoke document that you will not find online, as well as obtaining unanimous written consent from the owners. The company must also file articles of conversion, sometimes also referred to as a certificate of conversion, as well as articles of formation or incorporation with the Secretary of State in the destination state. After those documents are approved, a corresponding filing must be submitted to the Secretary of State or Department of State in the original jurisdiction to formally remove the company's domicile from that state. Each step must be executed in strict conformity with the statutory conversion procedures of both jurisdictions to ensure legal continuity and to avoid disruptions in tax reporting, liability protection, and contractual relationships. In contrast, foreign registration keeps the entity domiciled in its original state, requiring it to qualify and register in the new state as a so-called foreign entity. This means that the business remains subject to taxation and regulatory obligations in both states simultaneously, even if operations have ceased in the original state. On the other hand, a merger, which we usually do not recommend, involves forming a new company in the destination state and then merging the existing company into it. This can trigger unintended tax consequences under the Federal Internal Revenue Code, may require a new EIN application, possibly invalidate prior contracts or licenses, and delay the transfer of assets or credit history. Redomestication avoids all of these negative outcomes by maintaining legal and tax continuity. The redomestication process involves 6 discrete stages at Cummings and Cummings Law. First, submitting basic company and ownership information and payment to our firm website. And in case you are interested, the link is in the description below. Second, an optional telephone consultation to confirm basic facts and goals. Third, I or another attorney in my firm will draft the legal instruments, namely the plan of conversion, the articles of conversion, the articles of formation, the written consent, and other documents. Of course, I would then send those over to you by DocuSign for your electronic signature. We avoid snail mail and hard copy signatures whenever possible in my firm. Step 4, submitting those documents to the destination state, which of course is something that I handle on behalf of my clients, as well as responding to any correspondence that we receive from the secretaries of state during the process. 5, obtaining that approval. And by the way, I send written status updates every week to every client undergoing the redomestication process so that they are always in the loop and never in the dark as to what exactly is going on. And step 6, filing the final conversion paperwork with the prior state, which again is something we handle on behalf of our clients. This process ensures that the company ceases to exist in the former jurisdiction and becomes a domesticated entity under the new state's law. Throughout the process, the business retains its federal employer identification number, banking relationships, existing contracts, intellectual property, and legal identity. Redomestication is legally and procedurally distinct from the shortcuts often promoted by non-attorney online services or poorly advised filing services. For example, omitting the required plan of conversion or using improperly structured articles can result in rejection by the state authorities or a breakdown in legal continuity, exposing owners to personal liability or tax audit risk. Off the top of my head, I am aware of one individual who tried the do-it-yourself approach and lost, and I'm not exaggerating here, almost $15 million as a result, which could have been entirely avoided had he and I spent even just a few minutes on the phone beforehand. But I digress. As I said, attempting this process without expert review may also result in the entity being flagged as invalid or non-existing by banks, insurers, or vendors, further complicating operations. An inadvertent dissolution, which can happen when the documents are prepared or filed incorrectly, can result in massive tax problems for the business and its owners. That was the case that I mentioned just a moment ago. Post-conversion, companies may still need to coordinate with their accountants or CPA to file final state tax returns and change their address with the IRS using Form 8822B, among other filings. Those are additional services we can offer. However, I have found that most small business owners typically prefer to handle that themselves or already have a relationship with a trusted CPA or tax preparer. Finally, businesses that fail to complete proper redomestication and observe all of the requisite formalities risk operating unlawfully in the new state and incurring significant penalties, also forfeiting liability protection altogether. And if this sounds bad, well, I hate to say it, but it really is. And in some cases, it cannot be fixed. Moreover, failure to deregister in the former state may subject the company to continuing and unpredictable tax and regulatory obligations. A properly executed redomestication ensures legal compliance, can simplify tax filings, avoids duplicative administrative burdens, and preserves the company's contractual rights, employer identification number, and protections. When done correctly, it is a jurisdictional transfer, not a legal metamorphosis or workaround. The entire process generally takes 2 to 3 months, depending upon state processing times and whether expedited filings are requested, and that is something we can assist with on an as-needed basis. At my firm, we are able to handle most redomestications for a flat fee, and we have a 100% success rate in handling these complex transactions for clients on time and on budget. Again, my name is Chad Cummings, and I hope you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding the information in this video or in any of my other productions, please visit my firm website at the link in the description below to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.